Your freedoms are being taken. It is time for history to repeat itself and stand. Black Robe Patriots. Your host, Dr. Cindy Flowers and Pastor Ladina Boo.
Good morning, it's Ladina Boo from Stockton, Missouri. My co-host today, Dr. Cindy, will not be joining me. She is a student all the time, and she's very smart. She's already got her doctorate, and she is now working on another degree, and she has finals, and so consequently she's been spending a lot of time by her little self studying for her finals and getting her last paperwork in. So today it is just I, and we're going to be talking about what many refer to as the Forgotten Amendment. It's the Ninth Amendment, and it says the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, this was ratified in 1791. So when the Constitution was presented to the states for adoption, it contained no Bill of Rights. A majority of those who attended the Constitutional Convention decided that a Bill of Rights was necessary. They believed the powers granted to the federal government by the Constitution were so limited that the government could never become tyrannical. Also, the Constitution created a structure of government made up of three separate branches, each with a specific and separate set of powers, providing checks and balances. Unfortunately, those checks and balances are not working too well today. We're not getting the checks and balances, and our legislatures up there have gone ahead and made all of these little groups, the ATF, the FBI, the CIA, the Homeland Security, and everything. And so now, instead of following our Constitution the way they should be, they are stomping on those rights. And right now, we're pretty much ruled by administrative rules for these various departments of our government. So they're sidestepping our Constitution by the way that they're operating. Now, during the debate over the drafting of the Bill of Rights, James Madison expressed concern that it was impossible to list all of the rights that should be protected by the Constitution, and that the listing of some rights might imply the denial of any rights not listed. So the Ninth Amendment was written by the framers of the Bill of Rights as kind of a safety net for those legitimate rights that were not specifically mentioned. This is a bill under which Roe v. Wade was first put on the books because it was a right. It was a personal right, a personal decision of the woman whether or not she wanted to have an abortion. But during Roe v. Wade, whenever that was in place, you would find situations where people, specifically on Roe v. Wade, she wanted to be able to abort her baby. Now, she has stepped away from that. She was very upset in her later years about that particular thing being called Roe v. Wade, because she got back to the idea of, she shouldn't have killed her baby. And during that time also, if somebody murdered a pregnant woman, then they were charged with 2 counts of murder, one for her and one for the child. So if you're saying a child can be murdered by somebody else, then Roe v. Wade is, going against that particular concept. The Supreme Court has reversed Roe v. Wade, and so that's why we have lots and lots of protests from people saying, it's my body, my choice. Usually on the liberal side of the world. Myself, I was very happy when Roe v. Wade was reversed. most scholars will agree that the Ninth Amendment was intended to provide one more protection against the government's abuse of power. Other issues about this amendment are not so easily resolved. Did the framers see the amendment as a way to expand rights of the people in future ages? Should the courts use the amendment to identify and recognize new rights that seem desirable as new conditions develop over the years? Many scholars answered no, arguing that the framers had no such intention. The Ninth Amendment has been cited hundreds of times by federal and state courts, but rarely figured in Supreme Court decisions. In a few cases, the amendment provided general added support for specific constitutional rights, but no Supreme Court majority has ever precisely identified the rights retained by the people. And that is actually in that amendment, the rights retained by the people. In a few cases, the amendment provided general support for those specific constitutional rights, but no Supreme Court majority has ever precisely identified the rights retained by the people through the Ninth Amendment. The amendment did not even undergo any serious analysis in Supreme Court decisions until 1965. In this case, a minority of 3 justices were able to agree on one Ninth Amendment right, and that case happened to be Griswold versus Connecticut. In 1961, officers of the Planned Parenthood League of Connecticut were arrested for supplying and giving instructions in the use of contraceptive devices to married persons. A Connecticut law on the books since 1879 prohibited the use of any drug, medicinal article, or instrument for the purpose of preventing conception. Excuse me, my mouth isn't working today. So when the case reached the U.S. Supreme Court in 1965, the state of Connecticut argued that its law was designed to discourage extramarital sexual relations by making contraceptives unavailable to everyone. All the Supreme Court justices agreed the law was largely unenforceable and even silly, but was it unconstitutional? Justice Douglas, writing for the 7-2 majority, held that the Connecticut law violated the constitutional right of marital privacy. The Constitution, including the Bill of Rights, however, never specifically mentions any right of privacy. This fact did not deter Justice Douglas from concluding that various parts of the Bill of Rights create zones of privacy. He explained that although the right to privacy does not appear anywhere in writing, it exists as part of other rights that are written. Douglas found the right to privacy implied by freedom of assembly in the First Amendment, the prohibition against quartering soldiers in the Third Amendment, the guarantee against searches and seizures in the Fourth Amendment, and the rights retained by the people of the Ninth Amendment. He went on to say that the right of marital privacy is even older than the Bill of Rights. Nobody would sit around and discuss what happened in their bedroom with their husband or their wife. But agreeing that the anti-contraceptive law was unconstitutional, several justices differed somewhat with Justice Douglas over the constitutional basis of the right of marital privacy. Justice Goldberg, joined with 2 other members of the court, looked at the Ninth Amendment as the source of this right. Goldberg argued that the Ninth Amendment contains certain fundamental rights. To discover what these rights are, Goldberg wrote, the Supreme Court must refer to the traditions and collective conscience of our people. He concluded that the right of privacy in the marital relation is fundamental and basic, a personal right retained by the people within the meaning of the Ninth Amendment. 2 additional justices found that the Connecticut law was unconstitutional, but for a different reason than the violation of privacy rights. Justice White argued that the law of making the use of contraceptives illegal violated the 14th Amendment by depriving married persons of liberty without due process of law. 2 dissenters also found the law offensive but constitutional. Justice Stewart wrote that he could find no right to privacy anywhere in the Bill of Rights, in any other part of the Constitution, or in any case ever before decided by the court. And Justice Black stated it was not within the power of the Supreme Court to sit as a supervisory agency over acts of duly constituted legislative bodies and set aside their laws because they are unreasonable, unwise, arbitrary, capricious, or irrational. Both dissenters agreed that since the law did not violate any part of the Constitution, it was up to the people of the state and their elected lawmakers to change the law or take it off the books. So, since this 1965 case, only a few Supreme Court decisions have referred to the Ninth Amendment. The Supreme Court seems rather reluctant to interpret and apply the Ninth Amendment to its cases. One reason is found in the language of the amendment itself. By referring broadly to other rights retained by the people, the amendment gives little guidance as to which rights are retained. Some scholars have argued that if the Ninth Amendment were used to carve out new rights, the process would be almost endless. They point to the danger of activist judges using the amendment to justify creation of almost any right and invalidating federal and state legislation that interferes with these hypothetical rights. Ultimately, they argued that the amendment used in this way could upset the doctrine of separation of powers. Other scholars question this result. The Supreme Court, they argued, has often been called upon to interpret the Constitution, especially in the area of the 14th Amendment, due process and equal protection clauses, which are vague and as the language contained in the Ninth Amendment. While one can argue with the result, under this view, the court has shown the capacity to tread carefully when establishing new rights to avoid interfering with legislative power. So the question still remains, what rights are retained by the people? Are they only those rights that have been known would have been known in 1791 when the Bill of Rights was ratified, or are they those rights more broadly described by Justice Goldberg in his Griswold opinion, which are found to be found in the traditions and conscience of a people? There's difficulty in answering these questions. Helps explain why the Ninth Amendment has not become an important force in the work of the U.S. Supreme Court. While the Warren Court, which decided the Griswold case, was more willing to interpret the amendment of the Constitution to identify and establish new individual rights, later courts have been less willing to do so. The current court's Chief Justice is very conservative when it comes to carving out new rights through judicial interpretation. It seems unlikely that the present court will be tempted by the Ninth Amendment to do so. For the near future, except for the works of constitutional scholars, the Ninth will probably remain the Bill of Rights' forgotten amendment. So, there's a lot involved with the Ninth Amendment, and it's one of our primary sources of what we can and cannot do as private citizens. The Supreme Court and our legislative branches step on our rights on a daily basis. They have made their own decisions about what we can do. They're trying to take away our guns. They're trying to take away our ammunition. If you get into what they've done with the UN and so forth, they're trying to say that, our land really belongs to the federal government, and they're pushing out small farmers and so forth. And by 2030, the federal government intends to own 30% of the land in our nation. And the problem there is the fact that, they're pushing out all the small farmers. They're pushing out all the small cattle producers. And they're trying to let the federal government take over this. And if you watch a documentary on Epic TV, it's called No Farmers, No Food. And it goes into dramatic detail about what is happening around our world with regard to personal farms and our ability to do what we need to do in order to keep that farm going and, purchase more cattle or grow more crops. Instead, they're trying to push us to a manufactured um, food source. You've got to be careful about what they want you to eat because they're trying to push it to where we're eating bugs instead of uh, beef or pork because they don't, they say that those particular animals are contributing to global warming. I deny that fact. Okay. If you go back and you see, there's always been times of heat and times of cold and times of heat and times of cold. It's just a matter of fact situation with regard to our planet. And, this push to have us all eat plant-based meat or push us into eating bugs or, you know, have vaccines. They're putting vaccines in, they want you to eat vaccines now. Okay, I'm not a proponent of vaccines. And those vaccines are being put into our vegetables. If you want to order a salad, you're probably going to get vaccines through that lettuce, tomatoes, potatoes, anything of that nature. And my personal opinion, and we have our disclaimer at the start. This is my personal opinion, but they have vaccinated us into superbugs. We have so much vaccine. Our beef in the grocery store has so many vaccines in it and so many growth hormones that there is a problem happening. And they wonder why our people are getting fatter. They wonder why the penicillin and amoxicillin and so forth like that are not handling certain viruses in our bodies. But, we have over vaccinated everything. And so consequently, we're eating that and it's causing problems. It causes problems, with our autistic youth and so forth. We have much more individuals in our country with autism now than we have ever had in the past. If they start so far they're not pushing the vaccine on beef, but they've introduced vaccines into the pork. Most pork producers have certain vaccines that carry through after butchering, and you're eating that. And then they wonder how they can't get rid of various infections that people come up with, and they just call them superbugs. Well, you've vaccinated people to the point where they cannot, um, maintain their health. If you're going to go and buy food, my suggestion is you buy organically raised. Stay away from things that have been manipulated by scientists that tell you that, oh, this is good for you. You need to eat this. Well, they also say we need to eat bugs because it has enough protein for us. Well, I'm not in the mood to eat bugs. Okay, I've tried bugs. I've not had any mealworms, which is one of their big crops. I have eaten crickets and grasshoppers in the past with the Girl Scouts, but that's not my source of protein. And so we have this Ninth Amendment that says we have certain rights that we are retained for ourselves, where the government cannot step on us. And we have to learn how to stand up and fight against what they're doing. We've also got to talk about, a lot of the countries in Europe have banned the use of these modified seeds. They don't want you growing these modified seeds. I sit back and I'll flat tell you, if you are growing seeds that are not heirloom seeds, then you're growing a genetically modified plant. And like the corn that is grown these days, most of it, unless it's organic, like I say, they have various chemicals in these plants that if a bug bites it, it dies. Well, if it's going to kill a bug, why would I want to eat it? It's because that gets into your body too. Um, but we've got to understand our Constitution. We've got to understand our Bill of Rights, and we have to we have to argue for our rights. We have to try to get rid of all the administrative places and their rules and regulations, because those administrative rules and regulations are taking away from us the rights that are guaranteed in our Constitution. So, we've got to figure out how to get back to where we were. The Hamilton, who under George Washington was the nation's first Secretary of the Treasury, and others argued that listing some rights might give the government an excuse to take away rights that were not listed. James Wilson, a prominent Federalist politician from Pennsylvania who later served in the U.S. Supreme Court, said, enumerate all the rights of men. I am sure, sir, that no gentleman would have attempted such thing. To every suggestion concerning a Bill of Rights, the citizens of the United States may always say, we reserve the right to do what we please. We're seeing that a lot these days, but most of that is tyrannical stuff, instead of just going in and saying our Constitution says this, and voting in the people that will follow what our Constitution says. We have to get away from this administrative rule in our country. You see the ATF and so forth banning various things. You see the red flag laws, where your neighbor crawls on you and they come in and they take your guns, or they take everything else. So James Madison, he was a Virginia lawyer who later became the fourth president of the United States, was one of Virginia's representative in the House of Representatives of Congress. And Madison became a strong supporter of the new Constitution, but by 1789, he had come to support the addition of the Bill of Rights. He wrote the original draft of all 10 of the Bill of Rights amendments, but Madison agreed with other Federalists about the danger that a list of rights might imply that the people were only entitled to the rights listed. Now, Amendment 9 gives part of those rights back to us. It's a privacy right. It's you can do what you want with your body, and so forth. But the Supreme Court, established in the United States, originally consisted of 6 judges, and now it has included 9 justices. And the justices may write an opinion supporting either side of a given case, but the court's final ruling is left to a simple vote of the justices. The justices typically hear appeals of cases first heard in lower courts, and it holds the final power to interpret the country's laws, including the Constitution and its amendment. Yet the court has rarely tried to interpret the Ninth Amendment in the first 160 years since the passage of the Bill of Rights, and it's heard very few cases involving the Ninth Amendment. In those few cases, the court shed little light on what rights, if any, the Ninth Amendment protected. So in Ashwander versus the Tennessee Valley Authority, the Supreme Court described rights that were not protected by the amendment. The Ninth Amendment does not withdraw the rights that are expressly granted to the federal government. the court ruled. In other words, while the people may have rights that are not spelled out in the Constitution, no such rights can interfere with the government's right to do what the Constitution specifically says it can do. So in the Tennessee Electric Company versus the Tennessee Valley Authority case in 1939, the court ruled that the Ninth Amendment did not prevent the federal government from controlling the retail price of electrical energy. In that case, public utilities claimed that the government was interfering with their right to acquire property and use it in lawful business. But the court ruled that Congress had the constitutional right to regulate the prices because that power existed within the generally existing conception of governmental powers. Because those powers were granted to Congress by the Constitution, the Ninth Amendment could not be used to override them. So the Constitution gives us these rights, but they are not going to judge which rights are personal rights to us. One of the reasons the Ninth Amendment has played such a small role in constitutional cases is that the Supreme Court has often used the 14th Amendment, which was ratified in 1868, to establish broader rights for the people. The 14th Amendment's due process and equal protection clauses require federal and state governments to treat all citizens equally and fairly. And the Supreme Court has used this clause to establish civil rights and to strike down laws that violate certain individual rights, including those that are not specifically spelled out in the Constitution. Skinner versus Oklahoma in 1942, for instance, the court used the 14th Amendment Equal Protection Clause to uphold a person's right to procreate, have children, although the right to procreate is not listed anywhere in the Bill of Rights or the rest of the Constitution. The court found that the right was protected by the 14th Amendment. This ruling did not even mention the Ninth Amendment at all. The Ninth Amendment was first used by the Supreme Court to define an unenumerated right. If it's not specifically spelled out in the Constitution, like our right to free speech, our right to assembly, our right to own guns, all of the other rights that we've been talking about, we have to figure out what the court is doing there and how they're interpreting this. And that is the only way we're going to get our rights back. They're stomping on our rights on a daily basis. All this administrative law is taking everything out of our hands and putting it in the hands of government agencies that they don't care about you. I'm sorry, they don't. You have a few good eggs up in Congress, but a lot of them have been there forever. And I have come to the decision that they use the Constitution against us more than for us. They're not granting us the rights that our Constitution gives us. The Supreme Court, as I say, they found that the Connecticut law was unconstitutional. And so, you could now use contraceptives in Connecticut. The court in that particular case used other amendments as well, but that was the first one where the Ninth Amendment played a significant role. Now, Justice Arthur Goldberg was a very good champion of the Ninth Amendment. Like I say, it was largely ignored by the Supreme Court for a century and a half. But in the 1965 case, Justice Arthur Goldberg tried to give the Ninth Amendment substance. Estelle Griswold and Celie Buxton were convicted under a Connecticut law prohibiting the prescription of contraceptive devices. The Supreme Court overturned their convictions, ruling that the amendment is in the Constitution, especially the First, Third, Fourth, Fifth, and Ninth, acted together to create a right of privacy that protected such personal decisions from the use of the decisions as to the use of contraception in marriage. Justice Goldberg agreed with the decision, but argued that the court did not need to look beyond the Ninth Amendment to justify its ruling. The Ninth Amendment asserts that people have rights that are not necessarily spelled out in the Constitution. And to determine what these rights are, Goldberg said that judges must look at the traditions and collective conscience of our people to determine whether a principle is rooted there as to be ranked as fundamental. The right to privacy in marriage was just such a principle and therefore fell under the protection of the Ninth Amendment. And Justice Potter Stewart, in his dissent, questioned Goldberg's reliance on the Ninth Amendment by writing, but to say that the Ninth Amendment has anything to do with this case is to turn somersaults with history. Stewart believed that the Ninth Amendment had no relevance to the case. The Ninth Amendment had lain dormant for many years and was considered something of a constitutional curiosity. So, we've got to watch the Supreme Court decisions and see, are they taking your rights away from you? Are they putting more restrictions on your personal philosophies in life? And Roe v. Wade, in the 1850s, the American Medical Association urged state legislature to outlaw abortion, primarily because the procedures used at that time were considered dangerous. By 1900, most states had made abortion illegal. Women who wished to end their pregnancies sometimes found doctors willing to perform illegal abortions or chose to have their abortions performed by unskilled people. You see a lot of memes on Facebook and various places where the ones who want abortion free for all put up memes talking about the wire coat hangers and things of that nature. Everybody there is just trying to destroy a child, and I go back to my Bible, and it says not to harm a little child. Well, that thing growing in your stomach, that little body, is a person from the time of conception, or it's a person at least whenever they have a heartbeat. That is a living, breathing individual, and so killing that child, I believe, is murder. But by the 1950s and 60s, new medical procedures had made abortions much safer. But because abortions were still legal, many women were still risking these dangerous abortions. And the many professional groups, including the American Medical Association, announced that they now supported the legalization of abortion. And a few states got rid of their anti-abortion laws. By March 3rd of 1970, Norma McCorvey filed a suit in federal district court challenging a Texas law that made it illegal for her to have an abortion. She was 6 months pregnant at the time, and she used the fictitious name Jane Roe in the case to avoid unwanted publicity. So we have the Roe v. Wade there. The Supreme Court agreed that the law violated her right to privacy, but did not strike down the law to let McCorvey get an abortion. She has since stepped away from that particular mindset, and she is now a very staunch pro-life supporter. Roe v. Wade was put in there on January 22nd, 1973. And the court found that the right to privacy included a limited right to an abortion. By a vote of 7-2, the court held that the Due Process Clause of the 14th Amendment, which protects against state action, the right to privacy, included a woman's qualified right to terminate a pregnancy. But as I enumerated earlier, the courts have now come to the conclusion through medical science and understanding of the birth process and the formation of a child, and the fact that I don't know of any state doesn't say you've murdered 2 people if you go and murder a pregnant woman. We've got to remember that that is a child. So the Ninth Amendment basically says, if it's not written in the Constitution, then it's a state matter or it's a personal matter, and they try to keep it at that arm's length there. But you have to watch that your rights are not taken by our federal government or by the administrative rule of law that we have been suffering under through various presidents. And, we've got to get our country back to the basic Constitution and take away all these things from the ATF and the Homeland Security and so forth. Give the rights back to the people and stop stomping on them. Now, Dr. Cindy should be back with us next week, and sometime here in the next couple of weeks, she'll probably be here in person, and we'll be able to see her live here and on this show. And then her show on Wednesdays, which is called High Octane. On Wednesdays, I have a show called Trials and Triumphs. And we're working on triumphs for all of our children right now. That show is focusing a lot on this transgender ideology that has invaded our schools, pornography, and our schools and so forth. So, we're trying to bring awareness on a lot of subjects that are going on in our world today and make churches and individuals understand what's happening, the dangers of it, and how to protect yourself against it. So anyway, I am finished for this morning, and I thank you all for joining us. Like I say, please tune in on Wednesday. We have Cup of Sunrise with Joe and Stada at 8 o'clock. We have Len Morris and Don Blackard, or a guest host with Len Morris for Changing Times at 9 a.m. And then Dr. Cindy has a show called High Octane, which plays at 10 o'clock a.m. And then Trials and Triumphs is on at 11 o'clock on Wednesday. Those are all live productions, and they are all Central Standard Time. So I have to thank you for joining me today. And, I would ask that you tune in on Wednesday and give us your opinion on everything. If you have any questions, you can reach me at pastorladinaboo@gmail.com or Dr. Cindy at axmediagroup.com, and we'll be happy to try to get back with you. Thank you for joining me today, and I'll see you on Wednesday.